Bankruptcy. It's not available in every country, but we have it in the U.S. Bankruptcy is a separate section of federal law that provides for a fresh start. That's the genesis of it. That's where it all comes from, is to, if you run into trouble, get buried financially, whether a person or a company or some types of governmental units, then you can seek relief under the bankruptcy code. It was enacted by Congress. It's been modified several times, and it's still available for those who need its protection. There are two kinds that an individual can primarily use, Chapter 7 and Chapter 13. What that refers to is a section of the bankruptcy code. There is an actual Chapter 7 and a Chapter 13. Sometimes you hear somebody refer to a Chapter 20, which means a 7 turned into a 13 or vice versa. But we'll just start with the basics. Bankruptcy is a process. In a Chapter 7 bankruptcy, the person has to fulfill a means test, examining their income and their expenses based upon cost of living adjustments that are available in their community. These are fairly new standards that were enacted by Congress. But in general, if you have more debts than you can pay, you may be eligible for bankruptcy, taking into account not just your income, but also your assets. You do not need an attorney to file a bankruptcy as an individual, but it is highly recommended. This is a very specific area of law, and it's very tricky for people who are not familiar with reading code, etc. There will be attorney's fees involved necessarily. You might say, well, that doesn't make any sense. I can't pay my bills. How can I pay an attorney? Well, it may be more beneficial to you to save the money to pay this attorney if you have lots of creditors coming after you. A person is compelled to file a bankruptcy primarily because their creditors are waiting for payment, are tired of waiting for payment, and are now suing them. And as we cover in another video, creditors have certain rights against you to come after you to be paid money that you owe for a bank, on a house loan, a car loan, a credit card loan, etc. And if you have multiple people coming after you, you have all kinds of troubles, and it would probably help you to at least consult with a bankruptcy attorney. If you are eligible for a Chapter 7, then you will disclose all of your assets, all of your liability, all of your income, and all of your expense. There is a filing fee that is set by the courts, and you'll arrange for your payment to your attorney. The process is that you'll meet with your attorney, you'll fill out all the information, make sure that you're eligible, you'll sign declarations swearing that this information is correct, make sure everything is correct, and then the case will be filed. From the date that it is filed, there is an automatic stay imposed that stops anyone who is pursuing you. It immediately stops. They have different avenues to still try to impose their remedies and rights on you, but it's a different way. So you get a breather. Then there will be a creditors meeting. It's called a Section 341 meeting. All the creditors then can come in and ask questions about your schedules, because they will see your assets, income, etc. And your declaration of what assets you want to keep, what assets you're going to give back, and things like that. So then they will be able to come to the creditors meeting, there's one in every bankruptcy case, and ask you questions under oath about the schedules. Then there may be some other actions related to the bankruptcy, but if you truly have more debts than you do assets and you otherwise qualify, the trustee will then look over things. There's a trustee appointed for the court and for the benefit of other creditors to see that things are done appropriately, and to see if there are any assets available for the creditors to use to satisfy their debts. So he or she is a separate person that is in charge of that. Then after the trustee gives the clearance, then there is a discharge. Ultimately, which is what you want in a Chapter 7, that then you have an actual decree from a court that with regard to the creditors that you put on your list, except for student loans, taxes, and certain other things. Not everything is dischargeable, but from ordinary debt that you are responsible for, if you qualify, then you would ultimately receive a discharge, which means those debts are gone. Okay, they're gone. If you come into some money later and you want to pay somebody back, that's your decision, but you are not required to, and they cannot enforce it against you unless they've taken some other separate action. So you get a discharge and then you can start again. It's called giving you a fresh start. You can take advantage of this every 7 years. Then the other option for an individual that they may want to take advantage of or may have to, depending upon their assets and income, is Chapter 13. This is a restructuring. Again, there's a trustee. Again, there's schedules and information that's completed. The trustee here does the same job as the Chapter 7 trustee, but in a little bit different way. In a 13, you are going to be repaying certain creditors based upon your level of income through the trustee's office over a period of time. But again, at the conclusion of the plan, you would again receive a discharge. I hope that gives you some preliminary information.